The billing alert appeared at 11:47 p.m. on a Tuesday, flagging a template I hadn't touched in 3 months. I'm Cornelius Maplewood, 42 years old, contract attorney specializing in corporate mergers at one of Houston's most prestigious partnerships. 20 years of practice had taught me to trust my instincts about anomalies. This one felt wrong. The case management system showed my standard acquisition agreement template had been accessed 17 times in the past week. I'd used it twice. The modification timestamps didn't match my work schedule. Someone else had been editing my documents. I pulled up the template comparison tool. The current version looked identical to my original draft. Same headers, same clause structure, same formatting. But the system's metadata told a different story. File size had increased by 847 bytes. Version history showed subtle changes made during off hours. My secretary, Ophelia Eastwood, had administrative access to all my templates. She'd worked for the firm 8 years, handling document preparation for 3 different attorneys before me. Partners trusted her completely. Clients requested her by name for complex filings. I opened the template in edit mode and scrolled through each section. Purchase price provisions looked standard. Representations and warranties matched my usual language. Closing conditions appeared unchanged. Everything seemed normal until I reached the final pages. The disclaimer section had been restructured. What used to be prominent warning language about due diligence requirements was now buried in a dense footnote. The font size had been reduced to 8 points. Critical liability limitations were hidden in subclauses that most clients would never read carefully. These weren't accidental formatting changes. Someone had deliberately obscured important legal protections. My clients were signing agreements without understanding their exposure. I checked the access logs for my other templates. Employment contracts, partnership agreements, licensing deals all showed similar modification patterns. Late-night edits, increased file sizes, subtle restructuring that buried crucial disclaimers. My phone buzzed with an encrypted message from an unknown number. Check your retainer account tonight. The firm's financial portal required 2-factor authentication. I logged in and navigated to my client trust account. The balance showed $847,000, exactly what it should be based on my records. But the transaction history revealed something disturbing. Micro-transfers had been moving money in and out of the account for weeks, small amounts, always returned within 48 hours. Never enough to trigger automatic alerts or affect the final balance. Someone was using my client funds as a temporary loan source. The pattern was sophisticated. Transfers occurred during weekends when bank monitoring was minimal. Amounts stayed below the $10,000 reporting threshold. Return deposits came from different routing numbers, making the activity look like normal client payments. I printed the transaction reports and cross-referenced them with my case calendar. Every unauthorized transfer coincided with major deal closings I was handling. Someone with access to my schedule was timing these movements perfectly. The office felt different at midnight. Emergency lighting cast long shadows across empty cubicles. Security cameras tracked my movement through the corridors. I needed to examine the physical files before anyone else arrived. Ophelia's desk sat 20 feet from my office door. Her computer was locked, but paper documents were visible in her filing trays. I recognized several client names from recent transactions. The files looked thicker than they should be. Inside the first folder, I found duplicate signature pages for a merger agreement I'd closed last month. The client had signed 2 versions, one with the original disclaimer language, another with the buried footnotes. Only the compromised version had been filed with the court. My hands trembled as I checked the second file. Same pattern. Dual signature pages. Hidden disclaimers. Clients unknowingly waiving protections they thought they had. The elevator chimed in the distance. Someone else was in the building. I slipped the files back into their original positions and retreated to my office. The elevator doors opened with a soft ding. Footsteps echoed through the corridor. Measured, deliberate. I recognized the gate immediately. Ophelia Eastwood had been my secretary for 3 years. She arrived early, stayed late, and managed my practice with military precision. Partners praised her attention to detail. Clients trusted her completely. I'd recommended her for 2 salary increases. The betrayal started 18 months ago, though I didn't recognize it then. They invited me to co-counsel their most important cases. Stuart Eastwood, the managing partner, personally requested my involvement in the Morrison Industries acquisition. The deal required complex regulatory filings and tight deadlines. "Cornelius, we need someone who understands environmental compliance," Stuart had said during our initial meeting. "Your background in regulatory law makes you perfect for this." The Morrison deal was worth $340 million. My role involved drafting disclosure statements and liability waivers. Standard language protected both parties from unforeseen environmental issues. The disclaimers were crucial. Without them, our client faced unlimited exposure. Ophelia handled all document preparation. She'd worked late nights formatting signature pages and coordinating with opposing counsel. Her dedication impressed everyone. The deal closed successfully, and Stuart credited her organizational skills. But now I understood the real timeline. While I drafted protective language, Ophelia was creating alternate versions. She buried critical disclaimers in minor footnotes, using font sizes barely visible to aging executives. Clients signed documents thinking they had full protection. The pattern became clear as I reviewed other major cases. The Hartwell merger last spring, the Blackstone partnership agreement in July, the Riverside development contract in September. Each deal involved millions in potential liability. Each contained compromised disclaimer language. My phone buzzed with a text message. Unknown number. "Stop looking or everyone finds out about the trust account transfers." Someone was watching. The security cameras. The building access logs. Every movement was being monitored. I needed an ally. Stuart Eastwood couldn't be trusted. His enthusiasm for my involvement seemed suspicious now. The other partners barely knew me. But there was one person who might help. Stuart Eastwood worked in our litigation department. Different surname, no relation to the managing partner. We'd collaborated on several cases over the past year. His reputation for integrity was unquestioned. I called his direct line. "Stuart, I need to meet. Tonight, away from the office." "It's past midnight, Cornelius. What's wrong?" "I can't explain over the phone." "Meet me at the Starbucks on Westheimer in 20 minutes. The coffee shop was nearly empty. Stuart arrived wearing jeans and a concerned expression. I showed him the transaction reports and duplicate signature pages. His face darkened as he processed the implications. "How long has this been happening?" he asked. "At least 18 months. Maybe longer. The trust account activity goes back 2 years, but I only have records for the recent transfers." Stuart studied the documents carefully. These disclaimer modifications could expose our clients to massive liability. If environmental issues surface later, they'll have no legal protection. And our firm could face malpractice claims worth hundreds of millions. "Who else has access to your client files?" "Ophelia handles everything. Document preparation, filing deadlines, client communications. She has my electronic signature authorization for routine filings." Stuart leaned back in his chair. "We need more before we can. If we're wrong about this, we're not wrong. The pattern is too consistent. The timing is too precise. Then we need to document everything. Bank records, file modifications, computer access logs. Build a case that will hold up under scrutiny." I spent the next week gathering while maintaining normal routines. Ophelia showed no signs of suspicion. She continued managing my calendar, preparing documents, and coordinating with clients. Her performance remained flawless, but the digital trail was damning. Computer logs showed she'd accessed my signature authorization system dozens of times outside normal business hours. File modification timestamps revealed systematic changes to disclaimer language across multiple cases. The trust account transfers followed an even more sophisticated pattern. Money moved out on Friday afternoons, invested in short-term securities over weekends, then returned to Monday mornings with the profits skimmed off. The amounts were small enough to avoid detection, but substantial enough to generate significant returns. Stewart helped me trace the investment accounts. The profits were being funneled through a series of shell companies registered in Delaware. The ultimate beneficiary was a trust fund established for Ophelia's daughter's college education. On Thursday morning, I confronted them directly. Ophelia was formatting documents for a new acquisition when I entered her workspace. "I need to review the Morrison Industries files," I said casually. "Of course. They're in the cabinet behind my desk." I pulled the folder and examined the signature pages. 2 versions, just as I'd suspected. The filed version contained the compromised disclaimers. "Ophelia, why are there duplicate signature pages?" Her fingers stopped typing. For the first time in 3 years, she looked uncertain. "Sometimes clients request minor revisions after signing. We keep both versions for our records, but these aren't minor revisions. The disclaimer language is completely different." She turned to face me. Her expression had changed from uncertainty to calculation. "I don't know what you're implying, Cornelius. I'm not implying anything. I'm stating facts. You've been modifying critical disclaimer language and using my client trust account for unauthorized investments." The mask finally dropped. Ophelia's professional demeanor vanished, replaced by cold defiance. "You can't prove anything. I have bank records, computer logs, and physical. The State Bar will be very interested in your creative document management." She stood slowly, gathering her purse and jacket. "Those clients never read the fine print anyway. I just made it official." The confrontation ended with Ophelia walking out of the office at 2:47 p.m. on Thursday afternoon. She never returned. I immediately contacted the State Bar's disciplinary hotline. Within 6 hours, Senior Bar Investigator Amanda Davis from the White Collar Legal Fraud Response Group was sitting in our conference room reviewing the win. "This is extensive," Davis said, examining the bank records. "How long do you estimate this has been occurring?" "Based on the computer logs, at least 18 months. Possibly longer." Davis made notes in her tablet. "We'll need to freeze the trust accounts immediately and notify all affected clients." The firm's managing partner, Stuart Eastwood, arrived within the hour. His face was grim as I explained the situation. "How much exposure are we looking at?" Stuart asked. "Client damages could exceed $200,000. That's just the direct losses from the disclaimer modifications. The trust account skimming adds another $50,000. Stuart rubbed his temples. "What about malpractice coverage?" "Our carrier will likely deny coverage for intentional acts. We're looking at significant out-of-pocket settlements." Davis interrupted. "Mr. Maplewood, I need you to prepare a comprehensive timeline of all suspicious activities. We'll be filing formal charges against Ms. Eastwood within the week." The next morning brought the first client lawsuit. Morrison Industries filed a breach of contract claim, alleging that the modified disclaimers had cost them $3 million in a failed acquisition. Their attorney was demanding full discovery of our document management practices. I spent the weekend preparing damage control strategies. Stuart and I met with each affected client personally, explaining the situation and offering immediate settlements. Most accepted our proposals, but 3 clients retained separate counsel. On Monday, the State Bar issued a formal complaint against Ophelia. The charges included client fund misappropriation, document fraud, and breach of fiduciary duty. Criminal referrals were pending. Davis called Tuesday morning with an update. "We've located Ms. Eastwood. She's retained counsel and is cooperating with the investigation." "What's her defense?" "Claims she was following your instructions to streamline disclaimer language. Says the trust account transfers were authorized for investment purposes." I felt my jaw tighten. "That's completely false. We know. The computer logs show she accessed the templates when you were in court or client meetings." No authorization trail exists for the investment activities. The firm's insurance carrier sent their own investigator Wednesday afternoon. He spent 3 hours reviewing our internal controls and document retention policies. Your systems are actually quite robust, he told Stewart. This appears to be a deliberate circumvention rather than a systemic failure. Does that help our coverage position? Possibly. We'll need to see how the criminal investigation develops. Thursday brought news that Ophelia had been arrested. The district attorney's office filed charges of theft, money laundering, and computer fraud. Bail was set at $50,000. I testified before the State Bar disciplinary panel the following week. The hearing room was sterile and formal, with 5 attorneys sitting behind a mahogany table reviewing. Mr. Maplewood, did you ever authorize Ms. Eastwood to modify disclaimer language in client documents? Never. All template modifications required my written approval. What about the trust account investments? Absolutely unauthorized. Client funds are held in interest-bearing accounts only. No investment activities are permitted. The panel chair, a distinguished woman in her 60s, leaned. How did you discover these activities? Routine billing reconciliation revealed discrepancies. I investigated further and found the pattern of unauthorized modifications and transfers. Davis presented the state bars methodically. Bank records, computer logs, and document comparisons painted a clear picture of systematic fraud. The panel deliberated for 2 hours before announcing their findings. Ophelia's law license was suspended pending criminal proceedings. Restitution orders totaled $275,000. Stewart and I worked with Davis to establish a victim compensation fund. The firm contributed $100,000, with the remainder coming from asset recovery efforts. 3 months later, Ophelia pleaded guilty to felony theft and computer fraud. She received 2 years probation and was ordered to pay full restitution. Her law license was permanently revoked. The civil lawsuit settled within 6 months. Our total exposure reached $400,000, but insurance covered 60% after extensive negotiations. I implemented new security protocols throughout the firm. All template modifications now require dual approval. Trust account access was limited to partners only. Computer systems logged every document change with timestamp verification. Stewart promoted me to senior partner in recognition of my handling of the crisis. You saved this firm's reputation, he said during the announcement. The State Bar asked me to speak at their annual ethics conference about detecting internal fraud. My presentation focused on the importance of regular auditing and systematic oversight. Davis called in December with final case updates. Ms. Eastwood has completed her community service requirements. The restitution payments are current. Any other victims come? None. Your investigation appears to have caught this early. I helped 3 other firms that year deal with similar internal fraud cases. The patterns were remarkably consistent. Trusted employees with access to client funds and document systems, gradual escalation of unauthorized activities, and sophisticated concealment methods. The experience taught me that betrayal often comes from the most trusted sources. Ophelia had been the perfect secretary for 3 years before greed corrupted her judgment. But it also reinforced my faith in the legal system's ability to deliver justice when properly applied. 18 months later, I stood in my new corner office overlooking downtown Austin. The move from Houston had been necessary. Too many memories lingered in those familiar hallways. My new firm, Eastwood & Associates, specialized in legal ethics consulting. We helped law practices implement fraud prevention systems and conducted internal investigations when problems surfaced. The irony wasn't lost on me. Ophelia's betrayal had created my new career path. Stewart called monthly with updates from Houston. The firm had recovered completely. New clients trusted our enhanced security measures. The victim compensation fund had been fully distributed by October. You should consider coming back, he said during our last conversation. The partnership voted unanimously to offer you equity. I appreciate that, but Austin suits me better now. My calendar stayed full with speaking engagements and consulting and contracts. The State Bar had invited me to join their professional responsibility committee. I accepted, knowing firsthand how quickly trust could be weaponized. Davis visited in March to discuss a multi-firm investigation involving document tampering. "Your template fraud case helped us identify similar patterns in 3 other cities," she explained. "How many attorneys were affected?" 47 across Texas. "Your early detection prevented much larger losses." The validation felt good, but I'd learned not to take credit for luck. Finding those buried disclaimers had been pure chance during a routine file review. My new assistant, Rebecca Chen, had impeccable references and underwent extensive background screening. Trust would be earned slowly this time. The Austin legal community welcomed me warmly. I joined the Travis County Bar Association and volunteered for their ethics hotline. Helping younger attorneys navigate professional dilemmas reminded me why I'd chosen law originally. In September, I received an unexpected letter from Ophelia. She'd completed her probation and was working as a paralegal in San Antonio under supervised conditions. The letter contained a simple apology and a restitution check for the final balance. I deposited the check and filed the letter away. Forgiveness was possible, but forgetting remained difficult. My new practice thrived on prevention rather than prosecution. I trained senior partners on partnership equity pitfalls and helped firms establish bulletproof oversight systems. The work felt meaningful in ways that traditional litigation never had. Last week, a young associate from Dallas called about suspicious billing irregularities at her firm. I walked her through the investigation process, emphasizing documentation and systematic collection. "How do you know when to trust someone?" she asked. "You verify everything and hope for the best," I replied. The sunset painted Austin's skyline orange and gold as I finished reviewing security protocols for tomorrow's client meeting. My phone stayed silent. No emergency calls or crisis management tonight. It was finally over, and the silence felt earned.